All right, we're now going to shift our focus a bit to sort of government initiatives, again, whether it be laws, amendments, court cases that have some sort of like connection to gender issues and the fight for sort of like equal treatment based on gender. So we've already talked about this a little bit during the course of the year. We talked about, for example, with Congress, in the Congress unit, Title IX and its impact. This was a law passed in the early 1970s that essentially required any sort of, area of education, whether it be a public high school or a public university, that accepted any kind of like taxpayer provided government funding to provide equal opportunities for males and females. Especially, it wasn't just focused on that, but in areas of extracurricular opportunities such as sports. Prior to the passing of Title IX in the early 1970s, there were very limited opportunities for female students to participate in extracurriculars like sports, and Title IX's passing sort of definitely promoted greater sort of inclusion for women in these particular areas. And then we talked about Lilly Ledbetter a bit, who's pictured on the right, and the Lilly Ledbetter Fair Pay Act, which was the first law that was signed into being by President Obama in 2008, which basically, again, tried to reiterate the fact that paying males and females different for doing the same work would be illegal. And unfortunately, despite the fact that that law is in existence, there still is a gender pay gap that very much is in effect. It's narrowed over the decades, but unfortunately still is in effect. And there's a variety of reasons why that's in effect. But again, it's illegal to discriminate if you can prove that the sole reason you're being paid less is because of your gender. Then that's a discrimination lawsuit that you would have on your hands. But unfortunately, there are often factors that either are not made public or are other factors that employers can use to sort of continue these discriminatory policies. But as you can see, like the goal has narrowed a bit, but obviously the goal would be no distinctions based on gender when it comes to employment and compensation. If you look at like other really significant sort of steps, the 19th Amendment was literally the culmination of 100+ years worth of work trying to promote access for women to have suffrage rights, gaining the right to vote, which the passing of this amendment in 1920 finally provides women with this basic American right. One of the interesting things since the early 1980s is that women have become the largest sort of percentage of voters. Again, this has been pretty consistent, as you can see in the graph, since like the early 1980s. So obviously a significant voting force, but this was a right that was like long time in coming, and that generations of women had fought for, but finally earned the right in 1920. If we're looking at like significant court cases that deal with women's rights issues, we can sort of look at Roe v. Wade, which was the case that provided legal protection for a woman to have control over her body regarding the right to pursue an abortion. Obviously, this is an infamous case in American history involving an issue that very much divides the two political parties. There's religious arguments, scientific arguments, moral arguments, and this is one of those issues that definitely tend to divide people. But that is a right that women have based on the outcome of this Supreme Court case. The woman in the picture was Norma McCorvey, who was in her early 20s in the late 1960s when she became pregnant with her third child. She lived in Texas. Texas had laws that basically prevented, like many states at the time, women from having abortions. So she carried through with her pregnancy, had her child, put the child up for adoption, but the lawsuit still was filed, and though it didn't have an impact on her situation, would have obviously a major impact on women in the future. So this is the ruling, and sort of just a quick overview of it. in which legally the government sort of, through this verdict, looks at a woman's pregnancy in three sort of separate 3-month periods, each known as trimesters. A typical pregnancy is about 9 months. So within the first trimester, this is generally months 1 through 3, the government really has minimal involvement in sort of regulating what a woman can do with her body. There are certain steps they could take, like licensing clinics and facilities that would do the procedure. But ultimately, the government has to have a minimal amount of involvement over the process during this time period. The general trend is that as the pregnancy goes on, the state governments sort of retain a little bit more control over the process. So in the second trimester, months 4 through 6, the government has a bit of a greater ability to still regulate the process, but not ban the actual act of an abortion. And then when you get into the third trimester, this is months 7 through 9, governments can indeed ban abortions from taking place. And again, the general rule of thumb, the bottom line, is that any sort of state regulation that's put in place during that first 6 months, generally about 24 weeks, can't really have the sole purpose of making it more difficult for women to obtain an abortion. You can't place what the court refers to as an undue burden upon a woman, the right to choose what to do with her body. There has to be like something else that's sort of like leading to the regulation, not just making it more difficult for a person to have an abortion. And that's Norma McCorvey later in her life. I should mention, obviously, her name is not in the lawsuit. She's known as Jane Roe. She was allowed to remain anonymous in this court case. But you can see with the T-shirts in the background, she's a pretty interesting figure in the fact that, like, later on in her life, she actually became, she kind of like almost flipped sides. Even though her case was the case that led to legalized abortion, she later became part of the pro-life movement, and basically began to lobby the court to overturn the case that actually she was a part of, decades earlier. So she's kind of an interesting individual that she's been on both sides of this argument. Just as a quick example of, again, what the Supreme Court has kind of done by saying, like, okay, we're going to allow state governments in the first 6 months to put some regulations in place, is that they've opened the door for challenges, saying that, oh, well, this state's like policies are meant just to make it more difficult. They're not like common sense, like sort of arguments. And one such example is about 20 years after Roe v. Wade, involving our state, in which a group called Planned Parenthood sues the state of Pennsylvania. Casey is mentioned. That is Governor Robert Casey, who was the governor of Pennsylvania during this time period. The name may sound familiar. His son is one of the 2 senators from Pennsylvania currently, Bob Casey Jr. And basically what this did was, this was a Pennsylvania law that required 3 things. Number 1, it required any sort of minor that wanted to have an abortion would be required by Pennsylvania law to actually have parental permission before undergoing the procedure. It also established a 24-hour waiting period. There would have to be at least 24 hours in between the time period that someone went into a clinic or a medical facility expressing an interest in having an abortion and then having the actual procedure carried out. And then the third requirement was that women would have to notify their spouses prior to pursuing the abortion. So this was challenged by Planned Parenthood as an example of laws that were meant to sort of like make it more difficult for women to have an abortion. It was an undue burden that was being placed on a woman's right to choose. So this is kind of a mixed decision in that the Supreme Court looked at 3 critical elements of this law and basically said that they didn't have a problem with parental permission for minors and a 24-hour waiting period, that they seemed like fairly common sense regulations that weren't putting too much of a burden upon a woman's right to have an abortion. But they basically struck down the part of the Pennsylvania law that required spousal notifications, saying that this could put too much of a burden on a woman, that this would essentially be an issue that she needs to decide because it's her body, and that by having to notify a spouse, it's an extra burden that they shouldn't be exposed to. So 2/3 of the law was upheld and 1/3 disqualified. But like that's an example of like one of the things that one of these cases that was basically being heard by the court. And if we're looking at sort of like other sort of issues and the impact of Roe v. Wade, the Equal Rights Amendment in 1972 was proposed, and it would add that wording that you see on the screen, basically saying that equality of rights under the law shouldn't be denied or abridged based on someone's like sex, right? And there are a couple forces working against this amendment. This amendment was proposed by Congress, but it was never actually ratified by the states. So it's kind of like we're just hanging out there. Congress, when they proposed it and got the ball rolling to the states, basically put a deadline of 1979 in effect. And they didn't get the necessary number of states, 3/4 of them, to ratify this amendment by 72. And it's interesting, like, what would the objection be? Well, part of it's bad timing. Roe v. Wade, as you can imagine, was a super controversial decision, and many people felt frustrated that they didn't have any influence over the Supreme Court judges in that case. So when this was right around the same time, this is something you can put pressure on your local public officials to like not support. People kind of looked at like this was the thing that they could take their frustration out on, right? Like, oh, this is just too much at this point. And then besides just like being in the same general time period as Roe v. Wade, there was actually a pretty significant organization called STOP, which stands for Stop Taking Away Our Privileges, that, believe it or not, was led by a female, and she was very successful, Phyllis Schlafly, in opposing the ratification of the ERA amendment. And whatever primary sort of like arguments was that women in many cases enjoyed privileges because of their gender, and that if you had this wording in the Constitution, you wouldn't be able to get away with those privileges anymore, such as being exempt from the draft. 72, like Vietnam War is like wrapping up and going on. The argument was that, hey, if this goes into the Constitution, you're going to be draft eligible, right? Or you have enjoyed going to like single sex schools, like an all-female high school or all-female university. Like that wouldn't be possible if this was adopted. She convinced people that it would be the end of sort of like single sex bathrooms and that all genders would be in bathrooms together, and was very successful in mounting opposition to the ERA amendment. So the ERA amendment is never officially adopted and never goes into effect. So it's not obviously part of the Constitution. And then if we're looking at other sort of like significant gender-related issues, same-sex marriage and the argument over it came to a head in like right around 2013, 2014, 2015. And basically, if you look at the map, states have been allowed by the federal government to sort of decide for themselves whether or not they wanted to allow same-sex marriage. It was strictly a state decision. You can see the states in the red basically had laws in the books that made it illegal. Other states in the northeast part of the country was more prone to be legal. And like there just wasn't like universal agreement. And then you had situations like, well, like what if you got married in Massachusetts, which legalized it, but then you moved to a state that didn't recognize it? Would they have to honor the marriage? And there were all sorts of disputes. So eventually the Supreme Court stepped in 2015. They accepted a case in Obergefell v. Hodges in 2015, basically took the decision out of the hands of the states and basically declared that every state, all 50, had to permit same-sex marriages. So this basically took the decision over same-sex marriage out of the hands of the states and then sort of like universally applied legalized same-sex marriage across all 50 states, right? So again, these are some of the more prominent court cases, laws, and amendments surrounding the issue of like gender.